Well, here is now part two of working with the law as a part of General Introduction to Tax Law. And where we finished, that was the point where it came to different interpretations of the meaning of the law, and that if the traditional methods to interpret the meaning of the law do not really help to find one and only convincing interpretation, then if several different understandings are possible, then a decision must be made by a neutral instance, that is the courts. And so for everybody dealing with tax law, naturally also the way how a court system in a state is built up is of importance. So the fate of a tax notice, of the tax claim which the tax authorities demand from the taxpayer, that fate is as it is here outlined. For example, if the taxpayer does not agree with the tax authority's opinion, then you must first, in our system, appeal to the tax authorities if they stick to their opinion or if they want to give in and change their decision. After that has been decided by the authorities, only then you can go to court and start court proceedings. The reason behind that intermediate step is simply that it would be a waste of time, of the capacity of courts, and of money if, for example, somebody opens court proceedings, the taxpayer brings forward, I object the decision of the tax authorities because they applied the law wrongly, and then the judge asked the representative of the tax authorities, what do you think about that? And now if the tax authority says, yes, we think the taxpayer is entirely right, and then that would be completely unnecessary. And so it is a necessary step which is required, at least in our system here in Germany, that before you can place a complaint in court, you have to involve yourself with an objection to the fiscal authorities. Only after you got their final decision that in spite of your objection, they uphold their decision, then you can go to court. Then, as you know, there will be local courts. In Germany, they are called Finanzgericht, so the fiscal court. Usually, a country does not involve average judges into a tax matter because taxation laws are highly complicated. You must be an expert in the field, and so in a usual court, a regular court, you would probably be lost. So there are specialized courts with fiscal experts set up in different regions, and so you will have to go to your local competent fiscal court. That court examines the fact of the case, so the information on which the legal rules have to be applied, then forms an opinion of how the law should have been applied correctly and decides what the correct solution for that case is. Now it might be, as errors are human characteristics, that one of the persons involved, either the fiscal authority representative or the taxpayer, thinks that the fiscal court made something wrong or got something wrong, made an error in the application of the laws, and therefore asks a higher instance, that is in that case the Bundesfinanzhof, the Federal Fiscal Court, to review the court decision if mistakes can be found. That can only be done with regard to the application of the law to the facts of the case. The Bundesfinanzhof does not occupy itself again with the finding of the facts. Insofar, they rely on the local court. And they only review if the legal rules have been applied and interpreted correctly. That has, by the way, the negative consequence that if you forgot to mention something in the court proceedings before the fiscal court, some facts, you can never make that mistake good. So if the fiscal court applies the legal rules correctly, but to a situation which was not completely or which was misunderstood, then that is a fault which you or your tax advisor can never make good again, because the juridical review by the Bundesfinanzhof is only restricted to the application of the rules to the fact and not to the facts themselves. Apart from these two instances in the tax field, it might be that other courts also have an importance for taxation. That is, first, the Constitutional Court, which might be occupied with a case if a court or an authority thinks that a law or an interpretation of a law violates the German Constitution. And in that case, if a law violates the Constitution in Germany, it can be overruled by court decisions. And naturally, one didn't want to give that power to overrule a law to everybody, to every judge in the Republic. So that was centralized at the Federal Constitutional Court, the Bundesverfassungsgericht. And if a judge thinks a legal rule violates the Constitution, they have to hand over the case with that question to the Bundesverfassungsgericht, and then the judges there rule on the constitutionality of the rule or not. A similar system exists with regard to European Union law that has to be applied by every court in the land, but the interpretation of European law has to be uniform throughout the EU. So whenever a question arises if an EU rule is interpreted correctly, then the question how that rule has to be interpreted, especially with regard to the circumstance of such a case as the local court has to decide, that question is then referred over to the European Court of Justice, which debates the legal question, decides on the correct interpretation of EU law, and then hands back the case to decide that case to the local court, which then applies the interpretation of EU law which the ECJ has found. Court decisions in principle only decide the given case, at least in Germany. There is the one or other country in the world where things decided by a court stand and are legally binding. Under the German system, only the law itself is legally binding. So a court could always deviate, or even a lower court could deviate from the opinion of a higher court. But in practice, that doesn't happen very often, because naturally, when an authority deviates from the opinion of the Finanzgericht or of the BFH, the Federal Fiscal Court, then it's clear that the taxpayer will take them to court, and that then in the end the BFH ends up with the case and has to decide it again. And so if their opinion 2 years ago was that the law has to be understood in a certain way, their opinion now will be the same, unless very, very good and compelling arguments show up newly. So that is the reason why indirectly court decisions in Germany also are regarded as in a certain way indirectly binding. Nobody will deviate from a standing opinion of a court without that the law has been changed in the meantime, or without that very important arguments have shown up which nobody could expect. some years ago. That is also a very practical thing, because if everybody knows how a court is going to decide, that saves time and effort. If we know in advance that the Federal Fiscal Court, for example, will not accept a certain argument, if they never have done that, then it makes no sense to start court proceedings based on that argument. That leads to the widespread custom that court decisions are in an anonymous way published, so that the general public can inform itself over which arguments a court usually accepts and which arguments they usually do not accept as correct. So court decisions, especially the opinions of the court written down in the statements, in the judgments, are highly informative and are widely read by the by tax experts. But it might be that they are not absolutely binding. They decide formally, they are only decisions of the individual case. That is, by the way, a difference to the effect of a decision of the European Court of Justice, especially when it comes to a so-called preliminary ruling, where the case is referred, so handed over to the European Court of Justice, with the demand to answer only one question: how the correct interpretation of an EU rule is. Then what the Court of Justice of the EU hands back is not a decision for the individual case, but a general decision on the general interpretation of the rule in question. And that general statement on the correct interpretation has then to be applied by the local court on the course to the case in question. So decisions of the ECJ, at least in a preliminary ruling, are generally applicable binding opinions of the Court of Justice, which are applicable to every case which shows up in the future, until that court perhaps changes its jurisdiction, and they usually don't like to. Good. If you want to inform yourself about how the law is understood, then you come across a similar or an additional phenomenon, that is the so-called administrative directives or administrative rulings. There are several synonyms for that. That is binding orders given by the ministry, but not to the general citizen, because the government has not the power to decide about the opinion of citizens. But what they can do is they can give orders to their employees, to the civil servants, to the fiscal office employees, which opinions these people have to hold during the exercising of their duties. So to make it plain and simple, the problem is that the fiscal officers are bound by law. They have to apply the law to a case. But now, if the law can be understood in different ways, a chaos might result. It might be that if you live in Munich, your fiscal officer is Mr. Schmidt, and Mr. Schmidt understands the law in a certain way, and so you are taxed. In the end, you end up, let's say, with 500 euro of tax. Now it might be that somebody else lives in Hamburg, and there the fiscal officer responsible for the case is Mr. Müller. And Mr. Müller now has a different interpretation of the law in mind, thinks, well, in the same situation, somebody would have to pay 30,000. So he understands the law in the other potential possible way. So you end up with different payments, although the cases are comparable. That must be definitively avoided, because then fairness is no longer possible. Here, the real tax burden which the two persons in question had to bear did no longer depend on the rules in the law, but on the coincidence which interpretation of the law was held and followed by the officer in question who was dealing with the case. And that cannot convince. So what you must ensure, make certain, is that the fiscal administration takes care that your treatment is always equal, that equal cases are solved with an equal interpretation of the law, irrespective of which person deals with your case. And that is the sense behind so-called administrative directives or rulings. Here the fiscal administration decides which of potential interpretations their members have to follow and to apply during the exercise of their duties, so that it no longer depends on the personal ideas of the person who works on your case. Naturally, it is possible that the private opinion of such a civil servant is deviating from the official interpretation of the law, but makes no impact. That person has a right to a private opinion, but during your employment hours, you have to follow the orders of the boss. And the decisive thing, the positive aim which they want to ensure is that all persons are treated equal in equal circumstances, and that coincidence doesn't play a role. So that is the background of such administrative directives. The positive advantage for taxpayers is these directives also get published, and so by looking up there, you can find out if the wording of the law might make several different understandings possible. There you find out which opinion the fiscal administration members have to hold. So if your personal view of the law is identical with what is laid out in an administrative directive, you can be sure that there will be no dispute with the employee, the civil service in the fiscal administration who works on your case, because if it comes to different opinions, you can just show them the directive and tell them your boss, the ministry, orders you to follow and apply that opinion. Your deviating opinion is just your private fun. You have not to allow yourself to let that private opinion influence your behavior during office hours or with official affairs which you have to deal with. So you are on the safe side when you get the confirmation that the administration holds the same view or is ordered to hold the same view as you have. This naturally is a great advantage for the people involved. Such administrative directives or rulings are issued by the ministry or by the fiscal ministry of one of the German Länder. And naturally, as orders can only come from a superior to the subordinates, it's clear that, let's say, a regional authority like the Oberfinanzdirektion, so the local supervisory authority for a part of a land, can only give binding orders to its own superiors, subordinates. So the best authoritative source for such things is circular letters or official rulings issued with the authority of the Ministry of Fiscal Affairs of the Federation, because that is usually a statement where every civil service in the administration regards him or herself as bound by, at least to follow the official opinion of the ministry gives them the feeling that they are on the safe side and can make no error. Good. So keep in mind, administrative directives are binding for the officers in the fiscal administration. You have the right to hold a deviating opinion. Naturally, then that might give a conflict between you and the fiscal authorities. And naturally, what will happen if then such a conflict happens? You will end up in court because the fiscal authorities will base their decision on their opinion. You will stick to yours, and then you go to fiscal court and federal fiscal court, which then have to decide if the administrative directive holds the right view or if your interpretation of the law is the more convincing one. So you are only bound by law. Yeah? And naturally, the fiscal courts are also not bound by law because they are not subordinate to the ministry. They are independent and neutral and have to hear the arguments of both sides and then to decide. Good. Yeah. So I mentioned that already. Positive effect is if you see your opinion shows up in an administrative directive too, then you know there will be a conflict between you and the fiscal administration on the interpretation of the law. No? The same problem will occur in other states too, and probably if other states also want to avoid conflicting and contradictory behavior of their officials, they will probably coordinate the behavior of their officials by similar instruments, also by rulings or so. So a nice task for you would be try to find a textbook on your local tax law and look which courts, for example, have specialized on tax cases in your country, and how, for example, what's the parallel to our administrative directives in the administration of your own country. Yeah? So the problem that the different opinion of officers might influence the case by coincidence, that exists everywhere. So every administration will try to limit that risk. So have a look what other countries know. Yeah, good. Another aspect which we have not yet covered is that there is not only one law. You know, Parliament has the bad custom of writing one law after another. That is nearly everywhere on the earth the case. So many laws exist, and then it will be an automatic consequences that after a time the different laws will contradict each other. So there will be different rules which say completely different things. You can't follow both orders of the law, and that's especially hard because you are bound as a citizen and as an officer and everywhere you are bound to follow the law. So conflicting orders bring you into a conflict. Huh? Fortunately, that problem is well known to all law experts, and so there are well-known, well-established, and absolutely foolproof rules how a conflict between two contradicting orders by the laws have to be solved. Yeah? For example, you all know the everyday situation that you might have a traffic sign somewhere where nobody is allowed to park or even to stop his or her car there. Now an ambulance car parks there for half an hour and nobody says something against that. How is that possible? And the answer is, well, you have two conflicting rules. One says nobody is allowed to park here. And the other rule says an ambulance in an emergency situation has the right to drive and park everywhere. So that is a direct conflict, and naturally one of the two rules is applied and the other one is ignored. Well, the underlying rule, by the way, is here. The first one is a general rule applying to all situations. The second rule deals with a far more specific case. It's a special law for a special extraordinary situation. So it's meant as an exception. And naturally, when it comes to a conflict between a general rule and a special rule for exceptional cases, the special rule prevails, because it makes no sense to write a special rule if it cannot derogate from the general rule. The only sense of a special rule is that the legislator wanted to get away from the general rule for these special cases. So the first anti-conflict rule or conflict-solving rule is in general that a special law prevails over a general law in cases where both would be applicable. Good. Yeah. You have the same structure in tax law too. For example, in value-added tax, there is a general tax rate, the standard tax rate, and the rule is everything which is sold by an entrepreneur is subject to value-added tax of 19%. But there is a special rule that milk is subject to a VAT rate of 7%. Now, this is contradictory. Milk is first covered by the term everything, so that means should be 90%. But then you have a special rule, milk 7%. Naturally, the special rule prevails. Milk is 7% and not 90. Good. The same would also apply with income tax. And for example, the general rules on income tax would say pay taxes on your worldwide income, but there might be a double taxation treaty with another country like France, which then says certain income from France is exempt tax-free in Germany. It's not possible to follow both rules at the same time. You can't tax the complete worldwide income and leave the French income tax-free. Here again, the relationship is the rule on the income from France is far more specific than the general rule about your worldwide income. So the double taxation treaty rule that says French income, certain French income is tax-free in Germany is a special rule and has to be followed, whereas the worldwide income general rule has to be ignored. The special rule prevails over the general rule. Good. So the decisive thing is wherever you have contradictory commands by the law, you are bound by the law. Now you can't act contradictorily, so you have to renounce on the application of one rule and have to decide for the other rule. And naturally, as it would be arbitrary to leave the choice to you, the legislator made rules which rule has to be followed and which has to be ignored in case of conflicts. And so there are three generally anti-conflict rules or conflict-solving rules. The first rule is that the younger law, the most recent law, prevails over the older law. The ratio of this rule is what the parliament said at last, that is what they ordered at last, and that is what counts most. Like in a firm, what the boss ordered last, that counts more, because what you say at last, that revokes, contradicting commands which you gave before. Then number two is that rule which I already mentioned, the special law prevails over the general law. In Latin, lex specialis derogat de lege generali. So the special rule frees you of the application of the general rule. And last but not least, in states where you have several levels of legislating bodies, you usually have a rank of them. And so the rule of the higher authority prevails over the decision of the lower authority. That means, for example, within the Federation of Germany, that a federal law prevails over any law of one of the Länder. And in the relation between EU law, European Union law, and national law in Germany, there's also a clear hierarchy that European Union law prevails over national law, even over national constitutional law, and that's it. That plays more and more a role in the field of taxation because, as I already mentioned to you, the European Union has the competence to make own rules and or even to give orders to the national parliaments with effect to every area which has a bearing, a meaning, an impact on the functioning of the economy in the single European market. Here there are some examples for these conflict-solving rules. The first rule, for example, the younger law overrules the older law is the explanation for the frequent changes of tax law. For example, if you make a law in the year 2000 that the corporation tax rate is 25%, and in 2008 you make a new law that says it's now 15%, then 15% wins. That's clear. Okay. Especially interesting is the conflict between general rules and special rules, because the special rule changes the general situation, that's clear, but the problem is special rules are very often exceptions, and exceptions are to be interpreted in a narrow and restricted way. So what the exception does not mention, for that no exception exists. So an exception covers only the cases which are named or meant by it, and if you do something similar, then, well, the general rule is always applicable, and now the command revoking the general rule is missing for your specific case. So the general rule remains applicable, because the general rule is always only put aside if you have a revoking remark by the legislator, and that is missing for that case, for example. So you have, for example, 7% rate VAT for milk, you have 7% for water, which is delivered from, in a simple form, so water from the crane in your house, and you have 7% for coffee powder. And if you put all this together and shake it, and then sell it for €2, then the question is which rate will be applicable. Let's say the new product which you created from milk, water, and coffee powder is called Mappuccino. And shake it, close it, cool it, sell it. Now €2. What's the applicable tax rate? Well, rule number 1 is everything you sell costs 19% VAT. There is a contradictory rule, a special rule for milk, 7%. Now, the thing which you are selling, is it milk? No, it's milk with coffee and water in it, and that's not the same as milk. A milk where you filled in 3 espresso is no longer milk. Feed it to a baby, then you need you see the difference. So the special rule for milk is not applicable. Now, coffee powder, 7%. There's coffee powder in your Mappuccino. But the problem is it coffee powder? The law mentions coffee powder. No, it's no longer coffee powder. It's a drink. So forget about this. Rule is not applicable. Next item. There is also a special rule for 7% for water. Now, is this water what you're selling? No, it's coffee and milk in it, and a bit of water. So Again, negative result for the applicability of the special rule for water. So you have a general rule 90% which is applicable, and all the special rules which you could think of are not applicable at all. So the 90% command is not revoked by any applicable special rule, so you end up with 19%. Although you thought, oh, all the ingredients were 7%. I mixed it together and then the 7% were gone and the 19 came out. You regard that as not convincing. Law experts would not understand your problem. For them it's clear. You have a general rule, everything is 19%, and only for special cases in the field of value-added tax, usually the thing which are necessary for a decent survival or so. So the products which are also needed by the poor, there you find a reduced rate. Well, and a law expert would now even say, well, your Mappuccino product, €2, everything mixed together, cooled, and so that's not something which is the basic standard of life, even for the poor. That's rather a luxurious product that can already be detected or supported by the fact that the world could survive without having that product for the last 2000 years, and you only invented it 2 years ago. So that's not the basic standard or the basic need of life. So it was right for the legislator not to free that product, although it consisted of 3 ingredients which are basic standard of life. Well, and that is sometimes tricky, because if you profit from a special rule and then begin later to do not exactly what is described in that special rule, but do something similar, then you might out of the scope of your special rule and end up in the area where the general rule applies again, and that might make an enormous difference. Yeah. Okay. When it comes to the third rule, that EU rule overrules national rule as far as the conflict goes, then we have similar things. For example, very often you have a situation where the Income Tax Act of a country says we take 30,000 euro from a person with 100,000 euro if that person lives in our country. Now, if you have a citizen from another country of the EU, it might be that the law then says, well, if that person doesn't live in our country, then it has to pay 38,000. Now, EU law very often contains clauses that the people from other EU countries may not be discriminated on the grounds of their nationality. And that also applies to tax law. So in our case here, we would have 2 conflicting norms. The national law would say the citizen from the other EU state is ordered to pay 38,000 euro. Then EU law says, but the maximum you may demand is 30,000. Now you cannot collect 38 and limit yourself to 30. That's a contradiction. So you will have to decide when you apply the laws which order prevails over the other. Do I take 38, or is 30,000 the amount an inland person would have to pay? Is 30,000 the limit? And the answer would be yes. EU law has the higher rank. You have predominantly to follow the EU rule, so 30,000 makes a cut. Now, interestingly, what happens if the UK then leaves the EU, and so a UK citizen afterwards is no longer an EU citizen? Well, then you have in the national law still that clause: a citizen living in the EU has to pay, in the UK has to pay 38,000. Full stop. That is a rule which is valid, applicable, and there's no exception. And now you look into the EU rule, and surprise, the EU rule says citizens of member states are not allowed to be discriminated on grounds of their nationality. But now our UK citizen is no longer an EU citizen, so the rule is no longer applicable to the case of that person. So now you have one rule which says pay 38,000 and another rule which is silent on the case. No contradiction anymore. So national law remains because it is uncontradicted by EU law, and so your tax notice will then be 38. By the way, that's sometimes hard to find out to which cases EU law applies and to which not. That, for example, is one of the reasons why the ECJ, the European Court of Justice in Luxembourg, is very often contacted by fiscal courts with the request to interpret European Union discrimination rules or other rules if they apply to a certain case or not. So, yeah, that is clear. Note, the prevalence of one rule over the other only goes as far as the conflict goes, so that is exactly what I just told you. If you have a French citizen or if you have a UK citizen before 2020, then EU anti-discrimination rules are applicable to that citizen. Now, if we have an English citizen in the year of 2022 or so, that case is then governed by the German rule or by the national rule, which says pay the higher amount, and EU law remains silent on the case. So you have no conflict again. You have now only one valid rule which is applicable to the case, and for a conflict to be solved you need two applicable rules. So if the other rule is not applicable, then the one and only valid rule prevails uncontradicted, and so that person has to pay the full amount. Good. Interestingly, one does not always have the complete overview where rules exist and where not. Sometimes it happens that rules are overlooked even by the administration. For, let's say, 10 years, for example, that happened with a clause in a treaty between the EU and Switzerland where such a situation like here ended up with a surprising solution, namely that if we have again our case that country A, let's say Germany, says you pay 30,000 if you live here, but if you have the same income and you don't live here, then you pay 38,000. This would then be a valid command that, let's say, a Swiss citizen has to pay 38 on 100,000 euro from Germany. Now with a Swiss citizen, you would say, well, Switzerland, no member country of the EU, so a Swiss citizen has no right to claim non-discrimination under the rules of the Treaty of the Functioning of the European Union. Yes, and nevertheless, in the final effect, wrong, because there is also a treaty between the European Union and Switzerland on the treaty of the citizens of each other, and there is a clause in that treaty that in all member states of the EU and in the EU, citizens of Switzerland who take up a job as employees or take up an independent activity as natural persons and business in the EU area may not be discriminated by EU states or the EU. And that also covers the field of taxation and the other way around. And now then again you have a clause which says if it's a citizen from Switzerland, the limit for the tax Germany or another country can claim is the amount which an inland citizen would have to pay. And so here again you would have that conflict. National law says take 38 EU law says, but never take more than a comparable inland citizen would have to pay. EU law prevails, and so the tax notice would be cut at a level of 30,000. The authorities would write you a tax notice determining your payable tax to 30,000, because naturally the tax authorities are bound by the law, and naturally when they have two conflicting laws, naturally also the members of the fiscal administration have to apply the juridical rules and to give prevalence to one of the rules, especially or namely to that rule which has the higher rank under the law. So solution here also cut with 30,000. Keep in mind, whenever you have no conflict because the two or only one of the rules is really applicable, then that rule fully applies. If you have a partial conflict only, so that two rules only contradict partially, then every rule will be applicable as far as this is possible without violating the other rule, and only where you have a strict contradiction, one rule would have to back down and the other wins. There was a very strange example illustrating that. There was a country in Europe where they had the death penalty for murder. So in their criminal code, there was a rule that if you committed a murder, you had to be condemned to death. Now, that country had also signed the Convention of Human Rights in Europe, and in that convention there is one statement: the death penalty is not executed in the member states. So you had one law which said you have to be condemned to death, and the other, an execution is not allowed. That is a direct conflict, but only partially. In that country, strangely, the judges then developed the one and only solution for such an awkward situation. They could follow their criminal law, and they had to follow it by condemning you to death. The only thing forbidden by the Human Rights Convention was really to kill you. So you were in the morning condemned to death, and you got your pardon, which commuted your death penalty to lifelong imprisonment immediately afterwards, because they said what the contradicting law orders is not abolition of the death penalty, but only abolition of the execution of a death sentence. So we are still bound by the law as far as we have to give a death sentence. The only thing which the other law demands is that the death sentence is not executed, but that person is then subjected to another penalty, and that is then regularly lifelong imprisonment. So you see, sometimes the ways how law experts deal with conflicting laws can be strange, but it's always as far as a legislator didn't revoke an order, it still stands. And that explains such strange things. Good. Yeah. The next thing which we have to talk about is also the procedural aspects of law. So the rules, how you have to deal with cases. For example, if you are not agreeing with the opinion of the fiscal administration, and that is highly remarkable, because there you can make huge mistakes and lose your rights. And to teach you that, and to make you understand why such rules must exist and why they are a trap perhaps for people, that is again reserved for another small video which is soon to come. Now that should be enough for today. recover well from hearing all that stuff now and come back to the next video soon. Yeah, my standard recommendation: like this video if you liked it, and like it too if you don't like it. Then recommend it to people whom you hate, and yeah, enjoy the idea that these people wait for the funny passages in all these videos and suffer like hell. Yeah, and I could tell you many other things, but I really don't want to. Okay, till later or till another day.